on first contact with you, and he was with you for several minutes. He never mentioned marijuana. The only time he mentioned marijuana is when he went to his car. He ran your vehicle the first time, then he ran it the second time after calling someone and saying that he needed PC on the vehicle.
That's my case, too. That's the motion.
Hello. All right, this is set for a motion to suppress. State, are you ready with witnesses?
No, Your Honor. The witness that we need, Officer Lucio, formerly worked for Hollywood Park
Hill Country Village.
Hill Country Village PD, but no longer does so. He now works for Windcrest PD. I did not learn this information until Friday afternoon and was not able to request Officer Lucio to be present. State requests a reset. If the court denies it, we'll dismiss for missing witness.
All right, then what I'll do is this case is coming back this afternoon at 1:30. And it's going to proceed at 1:30. So you have till 1:30 to obtain your witness.
Understood.
Thank you.
The state already starts on shaky ground. They don't have their key witness, Officer Lucio, in court. Without him, the state has to scramble and even request a reset. Think about that. Their case depends on this officer's testimony. Yet they can't produce him. It's like showing up to a chess match without your queen. You have to ask, if your witness is so crucial, how are you not prepared for this hearing? Viewers, what do you think? Does this already scream weakness in the prosecution's case?
Judge, can I be excused till 1:30?
Yes. We're back on the record in 2024 CR 01 versus Simeon Alexander Nevels.
Yes.
Could I have parties announced for the record, please, for the state,
And pursue.
for the defense?
Robert Maurer for defendant, Your Honor.
And are you Mr. Nevels?
Yes, sir.
All right. So yesterday we had a hearing on a motion to suppress. The officer was called as a witness and you were also called as a witness. The state entered into evidence without objection, State's Exhibit number 1, which is a DVD of the stop of the vehicle and also the entirety of the interaction with the officer on the date of the alleged offense. And counsel, if you could give that to the court reporter so they can have it in their record, please. All right, the court reviewed State's Exhibit number 1 last night, and also I reviewed it again this morning to make sure. Well, there's a lot of coming from that room. All right, the court reviewed it again this morning just to make sure that I had everything that I was looking for with regards to State's Exhibit number 1. And also with regards to both the testimony of yourself and of the officer. All right. The court. That's a lot of noise. All right. When looking at the DVD and bearing in mind watching State's Exhibit number 1, also reviewing mentally the testimony of yourself and the officer, this is what the court finds. The stop was a legal stop. The stop was for speeding. On State's Exhibit number 1, you admit to going over the speed limit. The officer informed you of what the speed limit was. You informed the officer what you thought the speed limit was, but you admitted to the 47 miles per hour and I believe it was a 30 mile per hour zone. Then the next question becomes, did the officer have a right to search your vehicle if the officer in fact thought that there was a smell of marijuana? The case law is clear. If there is a smell of marijuana, an officer is allowed to search the vehicle. They are allowed specifically to search the trunk if they so choose to search your trunk. In this case, they searched the trunk and they found what they believe to be illegal substances. So the next question for the court becomes whether witnesses are credible or not. what the court viewed in State's Exhibit number 1. And if someone is objecting to what the court viewed and what the court is about to say, what is in State's Exhibit number 1, please do not hesitate to let the court know. You are pulled over. You're at an apartment complex. You tell the officer that you are there to see your girlfriend. The officer discusses with you, as he has a flashlight looking in your vehicle, the reason for the stop, which was for the speeding, which you agreed you were speeding. The officer asks for your insurance and driver's license. You tell the officer that you have your insurance information on your phone, but you would like to speak with your girlfriend. The officer asks, friend, and you state to him because, and I'm summarizing here, you state with him because your girlfriend was expecting you and you just want to let your girlfriend know what is occurring. The officer tells you not to do that. You continue to look on your phone for your insurance. You tell the officer, I promise you, I do have insurance, but I got the insurance online and I am looking for it. The officer continues to speak with you, and this goes on for several minutes. During that first contact with the officer does not mention whatsoever any smell of marijuana. The officer then leaves your vehicle and goes back to his vehicle and says he wants to check on something. The officer enters his vehicle, and there are phone calls that are coming into him, and he's...
The state already starts on shaky ground. They don't have their key witness, Officer Lucio, in court. Without him, the state has to scramble and even request a reset. Think about that. Their case depends on this officer's testimony, yet they can't produce him. That's like showing up to a chess match without your queen. You have to ask, if your witness is so crucial, how are you not prepared for this hearing? Viewers, what do you think? Does this already scream weakness in the prosecution's case?
Making phone calls out. On his screen that is in his vehicle, it appears to the court that he is running the vehicle. The court is unable to view exactly what is on the screen because the writing is very small and the video is not great. But when he runs your vehicle, the court sees that there are green lettering throughout the screen. And he's clicking on a button, and as he clicks on the button, the screen continues to go to what the court is assuming the next page, and that is green. He remains in the vehicle. Another call comes in, and then either he sends a call out or a call comes in to him, and he lets them know what's going on, and he says in the phone, I need PC for this vehicle. Then once he requests PC for the vehicle, then I see the screen again, and all of a sudden, the screen comes up with a bunch of red writing. The court is making an assumption because neither party asked what he meant when he said, I need PC of the vehicle. The court is assuming that that call was, I need probable cause for this vehicle. Then after he does that, he gets out of his car, comes back to your car, and he shines the flashlight on you again, and he says, why are you looking at Wells Fargo? And your response to him was, I'm looking at Wells Fargo because that's where my insurance comes out each month. I swear to you, I have insurance. He allows you to do that. Then he says something to the effect of, let me be honest with you. I smell marijuana in your car and you have this box. And you tell him that box is empty. He says, do you have any weapons or anything in the vehicle? Because I'm going to search your vehicle. And your response to him was, I have a samurai sword. Just as a side note, no, but that's what you tell him. So then he says, well, I smell marijuana, get out of the car. I'm searching your entire vehicle. He takes you to the back of the vehicle. He proceeds to handcuff you and tells you.
This is the turning point. The judge flat out states, the officer is not credible, and in legal terms, that's devastating, because once a court finds a witness unreliable, especially a law enforcement officer, their entire testimony crumbles. The judge emphasizes that marijuana was never mentioned until later, and that detail is enough to suppress the evidence. Translation: The supposed illegal substances found in the car cannot be used against the defendant. In one ruling, the state's case collapses like a house of cards.
You're not under arrest, but I'm doing it for my safety. Then he searches your vehicle. The court is going to find that the state's witness was not credible. And so I'm going to grant the motion to suppress, not based upon the fact that the search was improper or illegal. I'm basing it on the fact that the officer was not credible when the officer stated that he smelled marijuana in your car. And the reason for that is because on first contact with you, and he was with you for several minutes, he never mentioned marijuana. The only time he mentioned marijuana is when he went to his car. He ran your vehicle the first time, then he ran it the second time after calling someone and saying that he needed PC on the vehicle. The court is assuming that PC means probable cause to search, and he's looking for that and asking for them to give him PC. I could not understand or hear what conversation was going with whatever party he was on the phone with. But if he's asking someone for PC to search your vehicle, that means in the court's mind that he wasn't credible when he said he smelled marijuana. Anything else from either side?
No, Judge.
Yeah, Pro John.
Yes. Thank you.
Thank you, Judge. May be excused.